2 years ago, my own divorce attorney told me that my career as an international business consultant would guarantee I would lose custody of my children. Last month, that same lawyer stood up and cheered in the courtroom when the judge awarded me full custody and praised my dedication to providing my children with global opportunities and educational experiences that would shape their futures in extraordinary ways. Before we jump back in, tell us where you're tuning in from, and if this story touches you, make sure you're subscribed, because tomorrow, I've saved something extra special for you. My name is Victoria Chen, and I'm about to tell you how a bitter divorce battle that seemed designed to destroy my relationship with my children became the catalyst for building a stronger family foundation than I had ever imagined possible. This is the story of how refusing to compromise my values and my commitment to my children's growth led to a victory that no one believed was achievable. The phone call that changed everything came on a Tuesday morning in March, while I was reviewing quarterly reports in my home office in Bellevue, Washington. I had been expecting this call for weeks, but hearing the words still felt like receiving a physical blow. "Victoria, we need to discuss the custody arrangement," said Jennifer Morrison, the family law attorney I had hired to represent me in what I had hoped would be an amicable divorce from my husband of 12 years, Michael Chen. Michael's legal team has filed a motion requesting primary custody of Emma and Daniel, and they are using your travel schedule as evidence that you cannot provide stable care for the children. I set down my coffee cup with hands that had begun to tremble slightly. Emma was 10 years old, Daniel was 8, and they were the center of my world. Everything I had built in my career, every decision I had made about my professional development, had been guided by my commitment to providing them with opportunities and experiences that would expand their understanding of the world and their place in it. "What exactly are they claiming?" I asked, though I suspected I already knew the answer. Jennifer's voice carried the practiced neutrality of someone who delivered difficult news regularly. "They are arguing that your position as senior international business consultant requires excessive travel that disrupts the children's educational stability and emotional development. They have documented 43 business trips over the past 18 months, including extended assignments in Singapore, London, and Tokyo." The irony was profound and painful. The career that I had built specifically to provide Emma and Daniel with financial security and global perspective was being used as evidence that I was an unfit parent. Michael, who worked as a regional sales manager for a pharmaceutical company and traveled primarily within the Pacific Northwest, was positioning himself as the stable, present parent who could provide the consistency our children needed. "Jennifer, you know that I have never missed a school event, parent conference, or important milestone because of work travel. I have structured my entire professional life around being present for what matters most to my children." "I understand that, Victoria, and I believe you are an excellent mother. However, family court judges tend to favor arrangements that minimize disruption to children's routines. The opposing counsel is going to argue that international business travel, regardless of how well you manage it, creates inherent instability." This conversation was taking place against the backdrop of a divorce that had evolved from mutual agreement about incompatible life goals into a bitter legal battle over fundamental differences in how we believed our children should be raised. Michael and I had grown apart as our careers developed in different directions, but we had agreed initially that we both wanted what was best for Emma and Daniel. The turning point had come 6 months earlier when I had been offered a promotion to Director of International Partnerships, a position that would involve quarterly trips to our company's offices in Asia and Europe, but would also provide substantial salary increases and equity opportunities that could fund our children's college educations and graduate school if they chose to pursue advanced degrees. Michael had been adamantly opposed to my accepting the promotion, arguing that the increased travel would be detrimental to our family's stability. I had seen the opportunity as a chance to model for our children that women could pursue ambitious careers while maintaining strong family relationships, and that global experience was increasingly valuable in their generation's professional landscape. "You are prioritizing your career over your family," Michael had said during one of our final arguments before deciding to pursue divorce. "The children need a mother who is present, not someone who is constantly getting on airplanes to chase some corporate fantasy." I had tried to explain that my international work allowed me to provide perspectives and opportunities that would benefit our children throughout their lives. Emma had already expressed interest in studying abroad during college, and Daniel had become fascinated with different cultures and languages through the stories and experiences I shared from my business travels. I am not choosing career over family, I had replied. I am choosing to show our children that it is possible to pursue meaningful work while being a dedicated parent. I am teaching them that the world is larger than our immediate surroundings and that they have the capability to engage with it confidently. Our fundamental disagreement about how to prepare our children for their futures had made our marriage unsustainable, but I had not anticipated that Michael would use our philosophical differences as grounds for arguing that I should lose primary custody. Jennifer continued explaining the legal challenges we faced. Michael's attorney is going to present evidence that the children's academic performance and social development have suffered because of your frequent absences. They have documentation from teachers about missed parent volunteer opportunities and statements from other parents about your limited availability for playdates and social activities. That documentation is misleading and incomplete, I said, feeling frustration rising in my chest. I have maintained detailed records of every school activity, every parent-teacher conference, every medical appointment. I have never missed anything that was important to Emma and Daniel's development. I believe you, but we need to be prepared for how a judge might interpret the information they present. Family court decisions are often based on perceptions of stability and consistency, rather than detailed analysis of actual parenting effectiveness. The legal advice Jennifer was providing was practical, and based on her experience with similar cases, but it felt like a betrayal of everything I had worked to build as both a professional and a mother. I had spent years developing systems that allowed me to excel in my career while being fully present for my children's needs. I had invested in technology that enabled me to participate in school events remotely when necessary, and I had built a support network of family friends and childcare providers who ensured Emma and Daniel never felt neglected or abandoned. More importantly, I had consistently involved my children in understanding my work and its purpose. They knew that my business travels were not vacations or escapes from family responsibility, but opportunities to build relationships and solve problems that created value for our company's clients and employees. They had developed pride in my professional accomplishments and had begun to see international business as a field they might want to explore themselves. "What are you recommending as our strategy?" I asked Jennifer. "Honestly, Victoria, I think we should consider negotiating a shared custody arrangement that acknowledges Michael's concerns about travel while preserving your relationship with the children. If we fight for primary custody and lose, you could end up with significantly less time with Emma and Daniel than what we could secure through negotiation." Her recommendation felt like advice to surrender before the battle had even begun. I understood that Jennifer was trying to protect me from a potentially worse outcome, but accepting a shared custody arrangement would require me to fundamentally alter my career trajectory and abandon the professional goals that I believed would ultimately benefit my children. "Jennifer, I need you to understand something. This is not just about custody schedules or legal technicalities. This is about what kind of future I want to model for my children. If I accept the argument that pursuing an ambitious career makes me an unfit mother, I am teaching Emma that she should limit her own aspirations to conform to traditional expectations about motherhood." I paused, organizing my thoughts before continuing. "I am teaching Daniel that women who pursue leadership roles are somehow selfish or neglectful. I am validating the idea that global experience and international perspective are luxuries, rather than essential skills for their generation." Jennifer's response was measured but discouraging. "I appreciate your principles, Victoria, but family court judges are primarily concerned with immediate stability, rather than long-term philosophical considerations. We need to focus on what will convince a judge that your custody arrangement serves the children's best interests according to legal standards." This conversation crystallized something I had been reluctant to acknowledge. The legal system's approach to custody decisions was based on assumptions about parenting and family stability that did not account for the realities of modern professional life, or the benefits that global experience could provide to children's development. I was facing a choice between accepting a custody arrangement that would require me to limit my professional growth, and fighting for an outcome that my own attorney believed was unlikely to succeed. Neither option felt acceptable, but surrendering felt like betraying not only my own values but also the future I wanted to create for Emma and Daniel. "Jennifer, I need some time to consider our options," I said. "I will call you back tomorrow with my decision about how to proceed." After ending the call, I sat in my home office surrounded by photographs of business trips where Emma and Daniel had joined me during school breaks, awards I had received for international project management, and artwork my children had created, inspired by the stories I had shared about different cultures and business practices around the world. The divorce proceedings had already been emotionally and financially draining, but this custody challenge represented something much more significant than a legal dispute. It was a referendum on whether I could maintain my identity as both an ambitious professional and a dedicated mother, or whether I would be forced to choose between these aspects of myself. That evening, as I helped Emma with her geography homework about Southeast Asian economies and listened to Daniel practice conversational Spanish phrases he had learned from a colleague's child during one of my company's family events, I realized that my children were already benefiting from the global perspective that my career provided. They were developing cultural awareness, language skills, and international curiosity that would serve them throughout their lives. Emma looked up from her textbook and said, "Mom, when I grow up, I want to have a job like yours where I can travel to different countries and help companies solve problems. But I also want to have children and take them with me sometimes so they can learn about the world." Her comment confirmed what I had suspected, that my professional life was not competing with my role as a mother, but was actually enhancing my ability to prepare my children for their own futures. The custody battle was not just about legal arrangements. It was about whether I would be allowed to continue providing Emma and Daniel with the kind of upbringing that I believed would give them advantages in an increasingly connected global economy. Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel. It means a lot to us. Now back to the story. Daniel added, "I like when you tell us about the different places you visit for work. It makes me want to learn more languages so I can talk to people from other countries." These conversations with my children reinforced my conviction that I needed to fight for custody arrangements that would allow me to continue modeling the kind of life I wanted them to feel empowered to pursue. Accepting limitations on my career would send a message that their own ambitions should be constrained by traditional expectations rather than guided by their capabilities and interests. That night, I made a decision that would define the next 18 months of my life. I would not accept a negotiated settlement that required me to compromise my professional development or limit my ability to provide Emma and Daniel with global experiences. I would fight for primary custody, and I would prove that my international career was an asset to my children's development, rather than a liability. I called Jennifer the next morning with my decision. "I want to pursue primary custody," I told her. "I understand that this will be a difficult case, but I believe we can demonstrate that my career benefits my children's development, and that I have systems in place that ensure their needs are always prioritized." Jennifer's response was cautious but professional. "Victoria, I want to be completely honest with you about the challenges we face. The statistics for mothers in similar situations are not encouraging. However, if you are committed to this approach, I will do everything possible to present the strongest case for your parenting capabilities and the benefits of your professional experience." This conversation marked the beginning of a legal battle that would test every aspect of my character, my resourcefulness, and my commitment to my children's future. I had no way of knowing that this challenge would ultimately lead to outcomes that exceeded even my most optimistic expectations, or that the process of fighting for my family would teach me lessons about perseverance, strategy, and the power of refusing to accept limitations that others tried to impose. The next 18 months would prove that sometimes the most important battles are the ones that everyone tells you are impossible to win. The family court system represented completely uncharted territory for someone whose professional life involved negotiating international business agreements and managing complex corporate relationships. Within the first week of actively preparing for the custody battle, I discovered that the legal strategies that had served me well in boardrooms across 3 continents were not only ineffective in family court, but could actually be counterproductive to achieving the outcome I desperately needed. My initial approach reflected the systematic problem-solving methodology I had developed through years of international consulting work. I began by researching family law precedents, analyzing successful custody cases involving professional women, and developing comprehensive documentation of my parenting practices and children's developmental progress. I assumed that thorough preparation and logical presentation of evidence would be sufficient to demonstrate that my career enhanced rather than hindered my effectiveness as a mother. Jennifer Morrison, my family law attorney, quickly dispelled this assumption during our first strategic planning session following my decision to pursue primary custody. Her office, located in a converted Victorian house in downtown Seattle, felt worlds away from the sleek corporate environments where I typically conducted business. The walls were lined with family law textbooks and case studies rather than international business journals, and the atmosphere carried an emotional weight that was absent from even the most challenging corporate negotiations. Victoria, I need you to understand that family court operates according to different principles than the business world, Jennifer explained as we reviewed the initial documentation Michael's legal team had submitted. Judges are not making decisions based on objective performance metrics or logical cost-benefit analyses. They are making subjective judgments about what they believe serves children's emotional and psychological well-being. She spread across her desk a collection of photographs, school records, and witness statements that Michael's attorney had compiled to support his custody petition. The materials presented a narrative that was technically accurate but strategically misleading, highlighting instances when I had been traveling for business during school events while omitting context about my overall involvement in Emma and Daniel's educational and social development. This is a character assassination disguised as legal documentation, I said, examining photographs that showed Michael attending a school science fair alone while I participated via video conference from a client meeting in Singapore. The images captured a moment in time but ignored the weeks of preparation I had invested helping Emma develop her project about renewable energy sources, the specialized materials I had arranged to be delivered to her school, and the follow-up conversations we had about how her presentation could be improved for future competitions. Jennifer nodded with the weariness of someone who had seen similar tactics employed repeatedly. This is exactly the kind of narrative we are going to face. They are not technically lying, but they are presenting incomplete information in ways that support predetermined conclusions about your fitness as a mother. The documentation revealed the sophistication of Michael's legal strategy. His attorney had interviewed teachers, coaches, and other parents to gather statements about my limited availability for volunteer activities and informal social gatherings. They had requested school attendance records that showed instances when Emma or Daniel had been picked up by babysitters or family friends, rather than by me personally. They had even obtained photographs from social media accounts that showed me in international business settings, while my children were attending local events. How is this legal? I asked, feeling a combination of anger and bewilderment at the invasion of privacy these materials represented. Unfortunately, almost everything here falls within the boundaries of legitimate evidence gathering for custody proceedings, Jennifer replied. The court's primary concern is determining what arrangement serves the children's best interests, and attorneys are allowed to present evidence that they believe supports their arguments about parental fitness and stability. Quote, "The psychological impact of seeing my professional accomplishments and international experience reframed as evidence of parental neglect was more devastating than I had anticipated. Photographs of me presenting at business conferences in London and Tokyo, which I had previously viewed as documentation of professional success that would benefit my children's futures, were now being characterized as proof that I prioritized career advancement over family responsibilities. What they are not showing," I said, pointing to a photograph of me delivering a keynote presentation at an international trade conference, "is that Emma and Daniel were with me on that trip during their spring break. They attended cultural sites, practiced foreign languages with native speakers, and developed friendships with children from families in the international business community. That presentation was about sustainable business practices that will shape the economy they will enter as adults." Jennifer listened patiently, but her expression suggested that my perspective, while valid, would not necessarily resonate with family court judges who might view international travel as disruptive to children's stability, regardless of its educational value. "We need to develop a counter-narrative that addresses their concerns about travel while demonstrating the positive impact of your career on the children's development," she said. "However, I want you to be prepared for the possibility that we may not be able to overcome fundamental judicial biases about mothers who travel frequently for work." This conversation forced me to confront something I had been reluctant to acknowledge. The family court system operated according to traditional assumptions about motherhood and family stability, that had not evolved to accommodate the realities of modern professional life. The same international experience that made me valuable to corporate clients was being interpreted as evidence that I could not provide the consistency and presence that judges believed children required. Over the following weeks, I began developing a deeper understanding of the cultural and legal obstacles I faced. Family court judges, many of whom had built their careers during eras when mothers typically chose between professional advancement and family responsibilities, were applying frameworks that assumed frequent travel was inherently problematic for children's development. The legal precedents Jennifer shared with me revealed a pattern of custody decisions that favored parents who maintained traditional work schedules and geographic stability, even when the alternative parent offered superior financial resources, educational opportunities, and global perspectives. The system was designed to protect children from disruption, but it did not distinguish between harmful instability and beneficial exposure to diverse experiences. The challenge we face, Jennifer explained during one of our preparation sessions, is that the court system has not adapted to recognize the advantages that international professional experience can provide to children's development. We need to educate the judge about how your career actually enhances your parenting effectiveness rather than detracting from it. This insight led me to begin researching educational and developmental psychology literature about the benefits of global exposure for children's cognitive and social development. I discovered extensive research demonstrating that children who experienced diverse cultural environments developed superior problem-solving abilities, enhanced empathy and communication skills, and increased adaptability to changing circumstances. I also began documenting the specific ways that my international business experience had contributed to Emma and Daniel's educational advancement. Emma's fascination with renewable energy had been sparked by conversations about sustainability initiatives I had observed in Scandinavian countries. Daniel's interest in learning Spanish had developed through relationships with colleagues' children from Latin American countries who attended company family events. The children's academic record supported my argument that my career had enhanced rather than hindered their development. Both Emma and Daniel consistently performed above grade level in subjects related to geography, cultural studies, and international relations. Their teachers had noted their sophisticated understanding of global issues and their ability to communicate respectfully with peers from diverse backgrounds. However, translating this evidence into a legal strategy that would resonate with family court judges required skills that extended beyond my business consulting expertise. I needed to understand not only what evidence would be legally admissible, but how to present it in ways that would address judges' underlying concerns about stability and consistency. Jennifer recommended that I begin working with Dr. Sarah Rodriguez, a child psychologist who specialized in custody evaluations and had experience with cases involving professional parents with demanding travel schedules. Dr. Rodriguez's role would be to conduct comprehensive assessments of my parenting practices and the children's developmental progress, providing expert testimony about the impact of my career on their emotional and psychological well-being. Dr. Rodriguez has worked with several families where parental travel was a central issue, Jennifer explained. She understands how to evaluate and present evidence about the difference between disruptive instability and enriching exposure to diverse experiences. My first meeting with Dr. Rodriguez took place in her office in the University District, surrounded by child development research and assessment materials. She was a woman in her early 50s with the calm, analytical demeanor of someone accustomed to evaluating complex family dynamics and presenting objective findings in emotionally charged legal proceedings. "Victoria, I want you to understand that my evaluation will be completely objective," Dr. Rodriguez explained. "I will be assessing not only your parenting practices, but also the children's emotional responses to your travel schedule and their overall developmental progress. My testimony will reflect whatever conclusions the evidence supports, regardless of what either party hopes to hear." This commitment to objectivity was both reassuring and intimidating. Unlike business presentations where I could control the narrative and emphasize favorable data, the custody evaluation would require me to submit to comprehensive scrutiny of my parenting practices and accept whatever conclusions emerged from professional analysis. The evaluation process extended over several weeks and included individual interviews with Emma and Daniel, observation of our family interactions, review of school records and extracurricular activities, and detailed analysis of how I managed parenting responsibilities during business travel. Dr. Rodriguez also interviewed Michael, his family members, and various people in both of our support networks to develop a comprehensive understanding of our respective parenting approaches. The children's interviews were particularly crucial because their perspectives would carry significant weight in custody decisions. Emma and Daniel needed to articulate not only their preferences about living arrangements, but also their understanding of how my career affected their daily lives and future opportunities. Emma, who had always been mature and articulate for her age, explained to Dr. Rodriguez that she viewed my business travel as educational rather than disruptive. When Mom travels for work, she always explains where she is going and why it is important, Emma said, according to Dr. Rodriguez's notes. She brings back stories about different countries and helps me understand how business works in different places. I want to have a job like hers when I grow up because it lets you learn about the whole world. Daniel's perspective was equally supportive but reflected his younger age and different interests. I miss Mom when she travels, but she always calls me every day and helps me with homework even when she is in different time zones, he told Dr. Rodriguez. She brings back cool things from other countries and teaches me words in different languages. Dad does not like it when Mom travels, but I think her job is interesting. These interviews revealed that my children had developed sophisticated understanding of my work and its value, contradicting Michael's argument that my travel created emotional distress or developmental problems. However, Dr. Rodriguez also noted that the ongoing custody dispute was creating anxiety for both children, who were aware of the tension between their parents regarding my career choices. The children are clearly thriving academically and socially, Dr. Rodriguez shared with me during a preliminary feedback session. They demonstrate strong emotional bonds with both parents and have developed remarkable maturity and global awareness that appears to be directly related to their exposure to your professional experiences. However, she also identified areas where the custody arrangement needed to address the children's developmental needs. Emma and Daniel both expressed desire for more predictable communication schedules when you are traveling, and they would benefit from greater involvement in planning international trips that include them during school breaks. These insights helped me understand that winning the custody battle would require not only defending my current parenting practices, but also demonstrating my commitment to continuously improving how I balanced professional responsibilities with family needs. The evaluation process was revealing strengths I had not fully recognized while also identifying opportunities for enhancement that could benefit my children, regardless of the legal outcome. As I progressed through the evaluation process and legal preparation, I began to realize that this custody battle was forcing me to become a more intentional and strategic parent. The scrutiny was uncomfortable, but it was also pushing me to examine and improve aspects of my family life that I had previously managed intuitively rather than systematically. The stakes remained enormous, but I was beginning to understand that the process itself was teaching me valuable lessons about advocacy, documentation, and the importance of clearly articulating the value and purpose behind my choices as both a professional and a mother. The breakthrough in my understanding of how to navigate the custody battle came from an entirely unexpected source during a routine business trip to Portland, 3 months into the legal proceedings. I had been dreading this particular trip because it required me to miss Emma's school play, providing Michael's legal team with additional ammunition for their argument about my priorities and availability. However, this journey would introduce me to someone whose insights would fundamentally reshape my approach to the case and my understanding of how to present my story effectively. I was sitting in the departure lounge at Seattle-Tacoma International Airport, reviewing custody documentation on my laptop while waiting for my flight to Portland, when an elderly woman in the adjacent seat noticed my materials and initiated a conversation that would prove transformational. "Custody battle?" she asked with the directness of someone who had observed enough of life to speak plainly about difficult subjects. I looked up to find a woman in her early 70s with silver hair pulled back in an elegant chignon, wearing a tailored business suit that suggested professional authority despite her age. Her eyes held a combination of wisdom and warmth that made her question feel supportive rather than intrusive. "Yes," I replied cautiously, uncertain about discussing personal legal matters with a stranger, but sensing that this woman's interest was genuine rather than merely curious. "May I ask what the central issue is?" she continued. "I have considerable experience with family law matters, both personal and professional." Something in her manner encouraged me to share more detail than I typically would with someone I had just met. My ex-husband is arguing that my career as an international business consultant makes me unfit for primary custody of our children because of the travel requirements. His attorneys are claiming that frequent business trips create instability and demonstrate that I prioritize work over family. The woman's expression shifted to what appeared to be recognition rather than surprise, as if she had encountered similar situations previously. And what is your perspective on how your career affects your children? I believe my international experience provides them with educational opportunities and global perspectives that will benefit them throughout their lives, I explained. I have systems in place to ensure I am available for important events and decisions, and I involve them in understanding my work and its purpose. They are thriving academically and socially. She nodded thoughtfully before extending her hand in introduction. I am Margaret Walsh, retired family court judge and current consultant for complex custody cases involving professional parents. I spent 32 years on the bench dealing with exactly the type of situation you are describing. The coincidence was so remarkable that I wondered whether our encounter was entirely accidental. Margaret Walsh was not only a former family court judge, but according to the business card she handed me, she now worked as an expert consultant for attorneys handling custody cases involving high-achieving parents with demanding career requirements. Judge Walsh, what is your assessment of my situation based on what I have shared? I asked, realizing that I had unexpectedly gained access to insights from someone who understood both sides of custody proceedings from decades of professional experience. Margaret's response was measured and comprehensive, reflecting the analytical approach of someone accustomed to evaluating complex family dynamics. The challenge you face is not uncommon, and it reflects broader cultural tensions about how we define effective parenting in an increasingly globalized economy. Many family court judges were trained during eras when mothers typically chose between career advancement and family responsibilities, and they struggle to evaluate situations where those roles are integrated rather than competing. Quote, she paused to organize her thoughts before continuing. However, successful outcomes in cases like yours depend on three critical factors: comprehensive documentation of positive outcomes for the children, expert testimony that contextualizes your parenting approach within current research about child development, and strategic presentation of your case that addresses judges' underlying concerns about stability while highlighting the advantages of your approach. Margaret's analysis aligned with conclusions I had been developing through my work with Dr. Rodriguez, but her perspective as a former judge provided crucial insights about how family courts actually functioned versus how I had assumed they operated. The most important thing to understand, Margaret continued, is that judges want to see evidence that your parenting decisions are made with the children's best interests as the primary consideration, not as secondary benefits of your career choices. You need to demonstrate that your international work enhances your effectiveness as a mother, rather than competing with it. Quote, this distinction was subtle but potentially crucial. Instead of arguing that my career provided benefits for my children despite requiring travel, I needed to show that my professional experiences made me a better parent because of the skills, perspectives, and opportunities they generated. Can you give me specific examples of how to frame this argument? I asked, recognizing that Margaret's judicial experience could provide insights that my business background had not prepared me to develop independently. Margaret opened her briefcase and pulled out a legal pad, beginning to outline strategic approaches that reflected decades of experience with similar cases. First, you need to document not just your children's academic performance, but their development of specific skills and perspectives that can be directly attributed to your international experience. Language acquisition, cultural awareness, problem-solving abilities, adaptability to new environments. She continued writing as she spoke, creating what appeared to be a comprehensive framework for presenting my case. Second, you need expert testimony that explains how exposure to diverse cultures and global perspectives contributes to children's cognitive development and emotional intelligence. This is not opinion testimony, but evidence-based analysis of how your parenting approach aligns with current research about optimal child development. Margaret's third recommendation addressed what she identified as the most critical aspect of my case. Finally, you need to present a detailed plan for how you will maintain and enhance your parenting effectiveness as your children mature and your career continues to evolve. Judges want to see that you have thought systematically about long-term implications and have strategies for addressing potential challenges. The conversation continued for nearly 2 hours, extending through our flight delay and into the first portion of our journey to Portland. Margaret's insights were transforming my understanding not only of legal strategy, but of how to articulate the philosophy and methodology behind my approach to balancing professional and family responsibilities. The key insight, Margaret explained as we discussed the psychological evaluation process, is that effective parenting is not about minimizing all challenges or disruptions for children, but about preparing them to navigate an increasingly complex and interconnected world with confidence and competence. Your international experience provides them with skills and perspectives that will be essential for their generation. This framework helped me understand why my previous approach to the custody battle had been inadequate. I had been defending my choices rather than proactively demonstrating their value, and I had been responding to Michael's arguments rather than presenting my own compelling vision for our children's development. Margaret also provided specific tactical advice about how to present evidence and testimony effectively in family court proceedings. Judges respond to concrete examples rather than abstract principles, she explained. Instead of arguing that international travel is beneficial for children's development, show specific instances where Emma and Daniel gained measurable skills or knowledge through experiences related to your work. She recommended that I begin documenting the children's progress in areas directly related to my international experience, such as their language learning, cultural knowledge, and international awareness. She also suggested that I identify other families with similar circumstances who had achieved positive outcomes, providing context for the judge about successful models of combining demanding careers with effective parenting. One of the most powerful elements you can present, Margaret said, is evidence that your children are not only unharmed by your travel schedule, but are actually developing advantages that their peers do not possess. Academic performance, emotional maturity, global awareness, adaptability to change. As our conversation progressed, I began to understand that Margaret's interest in my case extended beyond casual assistance to a fellow traveler. Her questions became increasingly specific, and her recommendations more detailed, suggesting that she saw something in my situation that connected to her broader professional interests. "Victoria, I want to propose something that might benefit both of us," Margaret said as we prepared to land in Portland. "I am currently writing a book about custody cases involving international professionals, and I am looking for current examples that illustrate both the challenges and the potential solutions. Would you be interested in allowing me to follow your case and provide strategic consultation in exchange for using your experience as a case study?" The proposal was unexpected but immediately appealing. Margaret's expertise could provide significant advantages in developing and presenting my case, while my situation could contribute to research that might help other families facing similar challenges. "What would this arrangement involve?" I asked, recognizing that Margaret's involvement could potentially transform the trajectory of my custody battle. "I would review all of your case materials and provide strategic recommendations about evidence gathering, expert witness selection, and courtroom presentation," Margaret explained. "I would also introduce you to other professionals who specialize in custody cases involving international business families, and I would provide informal coaching about how to present yourself and your philosophy effectively during legal proceedings." Margaret's offer represented exactly the type of expert guidance that I had been seeking but had not known how to access. Her experience with family court proceedings, combined with her understanding of the cultural and legal challenges facing professional mothers, could provide insights that would be impossible to develop independently within the timeframe of my case. "In exchange," Margaret continued, "I would ask for permission to document your case as part of my research, with appropriate confidentiality protections and the right to review any material before publication. Your experience could provide valuable insights for other families and legal professionals dealing with similar situations." The collaboration Margaret was proposing aligned perfectly with my professional instincts about strategic partnerships and knowledge sharing. Rather than viewing my custody battle as an isolated personal challenge, I could contribute to broader understanding of how modern families navigate the intersection of demanding careers and effective parenting. "I accept your proposal," I said, recognizing that Margaret's mentorship could provide exactly the type of strategic advantage I needed while also serving a larger purpose beyond my individual circumstances. Our conversation established the foundation for a collaboration that would extend throughout the remainder of my custody proceedings. Margaret's guidance would prove instrumental not only in developing effective legal strategy, but in helping me understand how to present my case in ways that address judges' concerns, while highlighting the unique advantages my approach provided for Emma and Daniel's development. As we disembarked in Portland, Margaret handed me a detailed reading list about custody law, child development research, and strategic approaches to family court proceedings. Your homework for the next 2 weeks is to become an expert on how your parenting philosophy aligns with current research about optimal child development, she said. We are going to build a case that is so compelling and well documented that it becomes a model for other families rather than an exception to standard practices. The encounter with Margaret Walsh represented a turning point in my approach to the custody battle. Instead of simply defending my choices, I now had the expertise and strategic framework to present a proactive vision for how my career enhanced my effectiveness as a mother and contributed to my children's development in measurable and significant ways. More importantly, Margaret's mentorship provided me with confidence that my situation was not hopeless or unprecedented, but rather part of a broader evolution in how society understood the relationship between professional achievement and family responsibility. With her guidance, I began to see the custody battle not as a personal crisis, but as an opportunity to establish precedent for other families facing similar challenges. Under Margaret Walsh's strategic guidance, the following 6 weeks transformed into an intensive period of evidence gathering and case development that would test every analytical skill I had developed throughout my business consulting career. Margaret's approach was methodical and comprehensive, requiring me to document and quantify aspects of my parenting that I had previously managed intuitively. This systematic analysis would ultimately reveal strengths in my approach that I had not fully recognized, while simultaneously identifying areas where strategic improvements could strengthen both my case and my effectiveness as a mother. Margaret's first assignment was to create what she termed a parental impact portfolio that would demonstrate the measurable benefits my international career provided to Emma and Daniel's development. This documentation needed to extend beyond general assertions about the value of global exposure to specific, quantifiable evidence of skills and knowledge my children had acquired through experiences related to my professional responsibilities. Victoria, family court judges are skeptical of theoretical arguments about parenting philosophy, Margaret explained during our first formal strategic session, conducted via video conference while I was completing a client project in Vancouver. They respond to concrete evidence of positive outcomes that can be directly attributed to your approach. We need to build a case that is so thoroughly documented and strategically presented that it becomes impossible to dismiss as wishful thinking or self-justification. The portfolio development process required me to analyze my children's educational and social progress with the same rigor I applied to business performance assessments. Margaret provided detailed frameworks for documenting language acquisition, cultural competency development, academic achievement in international studies, and social skills related to cross-cultural communication. Emma's progress in Spanish language learning provided particularly compelling evidence. Through relationships developed during my business travel to Latin American markets, she had gained access to native Spanish speakers who served as informal tutors and conversation partners. Her school language assessment scores had improved dramatically over the past 2 years, placing her in the advanced proficiency category typically achieved by students with formal immersion experience. More significantly, Emma had begun corresponding with a 12-year-old girl in Colombia whose father worked for one of my client companies. Their email exchanges, conducted entirely in Spanish, covered topics ranging from educational systems and career aspirations to cultural traditions and family relationships. This correspondence demonstrated not only language proficiency, but sophisticated understanding of international perspectives and cross-cultural communication skills. Daniel's development showed different but equally impressive benefits from exposure to my international work. His fascination with geography and international economics had led him to create detailed maps and research projects about countries where I conducted business. His social studies teacher had noted his exceptional understanding of global trade relationships and economic interdependence, knowledge that extended far beyond typical fourth-grade curriculum requirements. The children's academic records supported Margaret's argument that my international experience was enhancing, rather than hindering their educational development. Both Emma and Daniel consistently scored above grade level in subjects related to world cultures, international relations, and global economics. Their teachers had documented their ability to provide unique perspectives during classroom discussions about international events and their leadership in school projects requiring research about foreign countries. Margaret also required me to document the systems and procedures I had developed to maintain consistent involvement in my children's daily lives despite irregular travel schedules. This analysis revealed a level of organization and intentionality that I had not previously recognized as noteworthy but which represented significant advantages in ensuring continuity of care and communication. My travel coordination system included detailed protocols for maintaining daily communication with Emma and Daniel regardless of time zone differences, prearranged coverage for school events and extracurricular activities when travel conflicts were unavoidable, and systematic documentation of important conversations and decisions to ensure nothing was overlooked due to physical absence. The communication protocols proved particularly sophisticated upon detailed analysis. I had developed scheduled video calls that occurred at consistent times relative to the children's routines rather than my travel schedule, ensuring they could depend on regular contact regardless of my location. These calls included structured elements such as homework review, discussion of daily activities, and planning for upcoming events, providing consistency and engagement that many parents failed to maintain, even when physically present. Jennifer Morrison, my attorney, initially expressed skepticism about the extensive documentation Margaret was requesting. "This level of detail seems excessive for a custody case," Jennifer observed during one of our case preparation meetings. "Most successful parents rely on more intuitive approaches to family management." Margaret's response illuminated the strategic necessity of this comprehensive approach. "Jennifer, Victoria is facing accusations that her career makes her an inadequate mother. Intuitive parenting approaches, however successful, will not overcome judicial bias against mothers who travel frequently for work. We need evidence that demonstrates not only that her children are thriving, but that they are developing advantages that would be impossible to achieve through traditional parenting approaches." The documentation process also required analysis of how my international business experience had influenced my parenting philosophy and methodology. Margaret guided me through articulating the specific skills and perspectives I had gained through global work that enhanced my effectiveness as a mother. Negotiation and conflict resolution skills developed through international business dealings had proven invaluable in helping Emma and Daniel navigate peer relationships and academic challenges. My experience facilitating communication between people from different cultural backgrounds had enhanced my ability to understand and respond to my children's emotional needs and developmental changes. Project management and strategic planning capabilities acquired through coordinating complex international initiatives had enabled me to structure my children's educational and extracurricular activities in ways that maximize their growth opportunities, while maintaining appropriate balance and avoiding overwhelming schedules. Perhaps most importantly, my exposure to diverse parenting approaches and educational systems through international business relationships had provided me with broader perspectives on child development that influenced my decisions about everything from academic expectations to social skill development. Margaret's analysis revealed that these skills represented competitive advantages in parenting effectiveness that were difficult to acquire through purely domestic experience. The strategic thinking, cultural sensitivity, and organizational capabilities required for successful international business translated directly into enhanced parenting competencies that benefited my children in measurable ways. The testing phase also included development of expert witness testimony that would contextualize my parenting approach within current research about optimal child development. Margaret introduced me to Dr. Elena Vasquez, a developmental psychologist who specialized in research about the benefits of cultural diversity and international exposure for children's cognitive and emotional development. Dr. Vasquez's initial assessment of Emma and Daniel's developmental progress provided compelling support for the positive impact of my career on their growth. Her evaluation revealed that both children demonstrated advanced capabilities in areas directly related to global awareness and cross-cultural competency. Emma and Daniel show remarkable emotional intelligence and adaptability compared to their peers, Dr. Vasquez explained during her preliminary report presentation. They demonstrate sophisticated understanding of cultural differences, advanced communication skills, and exceptional ability to navigate new environments and relationships. These capabilities are directly attributable to their exposure to international perspectives through their mother's career. Her research analysis indicated that children who experienced structured exposure to international cultures and global perspectives during elementary school years developed cognitive advantages that persisted throughout their academic and professional development. These advantages included enhanced problem-solving abilities, increased creativity and innovation, superior communication skills, and greater adaptability to changing circumstances. Dr. Vasquez's testimony would prove crucial in addressing judicial concerns about travel-related instability by demonstrating that carefully managed international exposure actually contributed to children's resilience and competence, rather than creating developmental problems. The expert witness development process also included identification of other families who had successfully combined demanding international careers with effective parenting. Margaret's network provided access to 3 families whose circumstances paralleled mine and who had achieved positive custody outcomes despite initial challenges related to travel requirements. These case studies demonstrated that successful resolution of custody disputes involving international professionals required comprehensive documentation of positive outcomes, expert testimony about developmental benefits, and strategic presentation of long-term advantages for children's preparation for global economic participation. One particularly relevant case involved a woman whose career as an international development consultant had initially been viewed as incompatible with primary custody responsibilities. Through systematic documentation of her children's academic and social progress, expert testimony about the benefits of global awareness, and strategic legal presentation, she had not only retained primary custody, but had established precedent for recognizing international professional experience as a parenting asset rather than liability. Margaret's guidance also included preparation for the psychological evaluation process that would assess my fitness as a parent and the children's adjustment to our current living arrangements. This preparation involved practice interviews, role-playing exercises for different scenarios, and strategic coaching about how to present my parenting philosophy and practices in ways that would resonate with evaluators. The key to successful psychological evaluation, Margaret explained, is demonstrating consistency between your stated values and your actual practices, while showing that your decisions are made with the children's best interests as the primary consideration, rather than as secondary benefits of your career choices. This distinction required careful articulation of how my professional responsibilities were structured around my family priorities rather than competing with them. The evaluation would assess whether my travel schedule and career demands created stress or instability for Emma and Daniel, or whether they had adapted successfully to the opportunities and challenges of our lifestyle. The testing phase culminated with development of a comprehensive case presentation strategy that would address every argument Michael's legal team had raised, while proactively demonstrating the unique advantages my approach provided for our children's development. Margaret's framework included specific responses to concerns about travel frequency, detailed evidence of positive developmental outcomes, expert testimony about the benefits of global exposure, and strategic presentation of long-term advantages for Emma and Daniel's future success. "We are not simply defending your right to maintain your current career," Margaret explained as we reviewed the completed case materials. "We are demonstrating that your international experience makes you a more effective parent, and that your children are developing advantages that will serve them throughout their lives." This is a proactive case for excellence rather than a defensive response to criticism. The 6 weeks of intensive preparation had transformed my understanding of both the legal challenges I faced and the strengths I brought to parenting. Margaret's systematic approach had revealed evidence of success that I had not previously recognized, while providing strategic framework for presenting my case in ways that would address judicial concerns and highlight the unique benefits of my approach. More importantly, the testing phase had enhanced my confidence in the value of my parenting philosophy and my ability to articulate its benefits effectively. Rather than feeling defensive about my career choices, I now possessed comprehensive evidence that my international experience was providing Emma and Daniel with educational opportunities and developmental advantages that would benefit them throughout their lives. The foundation was now established for presenting a case that would challenge traditional assumptions about the relationship between demanding careers and effective parenting, while demonstrating that thoughtful integration of professional and family responsibilities could create superior outcomes for children's development and preparation for future success. The revelation that would fundamentally reshape the entire trajectory of my custody case came through an unexpected discovery during what appeared to be routine evidence review. 4 months into the legal proceedings, while analyzing financial documents that Michael's attorneys had submitted as evidence of his stability and consistent presence in our children's lives, Margaret Walsh identified discrepancies that suggested a far more complex situation than any of us had previously understood. Margaret had been systematically reviewing all materials submitted by opposing counsel when she noticed irregularities in Michael's employment records and travel documentation that did not align with his claims about maintaining consistent local presence for Emma and Daniel. Her experience as a family court judge had taught her to examine evidence, not only for what it revealed directly, but for what patterns might indicate about information that was being withheld or misrepresented. Victoria, I need you to look at these employment records and tell me whether they match your understanding of Michael's work responsibilities over the past 2 years, Margaret said during one of our weekly strategy sessions, spreading across her desk a collection of documents that Michael's legal team had provided to support their argument about his stability and availability for parenting duties. The employment records indicated that Michael worked as a regional sales manager for Pacific Northwest Pharmaceutical Solutions, a position that his attorneys had characterized as requiring minimal travel and providing consistent availability for school events and family responsibilities. However, Margaret's analysis revealed expense reports and travel reimbursement records that painted a significantly different picture of his actual work requirements. According to the expense documentation, Michael had traveled extensively throughout Washington, Oregon, Idaho, and Northern California over the previous 18 months, with trips occurring approximately twice per week and often requiring overnight stays in distant cities. The travel pattern suggested that his position involved far more client site visits and regional territory management than his legal representation had disclosed. These expense reports show travel to Spokane, Boise, Sacramento, and Portland occurring with remarkable frequency, Margaret observed, highlighting specific entries that demonstrated patterns of absence from Seattle during weekdays and occasional weekends. This level of travel suggests that his characterization of himself as the consistently present parent may be inaccurate or incomplete. The discovery prompted Margaret to request additional documentation from Michael's employer through formal legal discovery processes. As an experienced family law practitioner, she understood that misrepresentation of work responsibilities in custody proceedings could constitute grounds for challenging the credibility of other claims made by opposing parties. The response to our discovery request revealed information that was far more significant than the travel discrepancies we had initially identified. Pacific Northwest Pharmaceutical Solutions confirmed that Michael's position had evolved substantially over the past year, with his responsibilities expanding to include oversight of sales operations across 4 western states. This expansion had occurred approximately 6 months before he filed for divorce, suggesting that his increased travel obligations had developed during the same period when he was criticizing my international business responsibilities. More importantly, the employment records revealed that Michael had applied for and accepted a promotion to Regional Director of Western Operations, a position that would require relocation to Portland, Oregon within the following 6 months. This information had not been disclosed during any previous legal proceedings or settlement discussions, despite its obvious relevance to custody arrangements and the children's stability. Jennifer Morrison, my attorney, immediately recognized the significance of this discovery. Victoria, if Michael has accepted a position that requires relocation to Portland without disclosing this to the court, it fundamentally changes the entire premise of his custody petition, she explained during an emergency consultation following Margaret's findings. His argument about providing stability and consistent presence becomes impossible to maintain if he is planning to move our children to a different state. The revelation prompted a comprehensive investigation into Michael's actual intentions regarding post-divorce living arrangements and career development. Margaret's guidance proved invaluable in structuring discovery requests that would reveal the full scope of information that had been withheld from legal proceedings. Additional documentation requests revealed that Michael had already signed a lease for an apartment in Portland's Pearl District, scheduled to begin occupancy within 60 days. He had also enrolled Emma and Daniel in Portland public schools for the following academic year, completing registration processes that required substantial advance planning and commitment. The evidence suggested that Michael's entire custody strategy had been based on plans to relocate our children to Portland, while characterizing my Seattle-based career as disruptive to their stability. He had argued that my international travel made me unsuitable for primary custody, while simultaneously planning to remove Emma and Daniel from their current school, friends, and community support systems. This represents a fundamental misrepresentation of his intentions and circumstances, Margaret explained as we analyzed the full scope of evidence that had been uncovered. The court was making decisions based on incomplete and potentially misleading information about the stability and consistency each parent could provide. The discovery process also revealed that Michael's criticism of my international travel had occurred during the same period when his own travel responsibilities had increased substantially. According to his employment records, he had been absent from Seattle for business purposes more than 40 nights during the 6 months preceding his custody petition, a frequency that rivaled my own business travel during typical periods. More significantly, his expense reports indicated that many of his business trips had been extended beyond necessary duration, with additional personal activities and entertainment expenses that suggested he was using business travel opportunities for personal recreation rather than focusing solely on professional responsibilities. The contrast is striking, Margaret observed as we reviewed comparative documentation of our respective travel patterns and purposes. Your international business travel is carefully planned around the children's schedules and educational calendar, with systematic protocols for maintaining communication and involvement in their daily activities. Michael's travel appears to be driven by his career advancement goals with less consideration for family impact. The evidence-gathering process revealed additional information that contradicted other aspects of Michael's legal arguments. His claim that my career prevented me from maintaining consistent involvement in Emma and Daniel's educational development was undermined by school records showing that I had attended more parent-teacher conferences, school board meetings, and educational planning sessions than he had during the preceding academic year. Documentation from Emma's and Daniel's schools indicated that I had been the primary contact for academic planning, medical issues, and extracurricular coordination throughout their elementary school years. Teachers and administrators consistently communicated with me regarding educational decisions, behavioral concerns, and progress assessments, suggesting that my role as primary educational advocate was well established and effective despite my travel schedule. The revelation of Michael's undisclosed relocation plans also cast new light on his motivations for pursuing custody arrangements that would limit my decision-making authority regarding the children's education and residence. If he had succeeded in obtaining primary custody based on arguments about my travel instability, he would have gained legal authority to relocate Emma and Daniel to Portland without requiring my consent or court approval. Margaret's analysis suggested that Michael's custody strategy had been designed not only to obtain primary parenting time, but to eliminate my ability to object to significant changes in our children's living situation and educational environment. The timing of his job promotion and relocation plans, occurring concurrent with divorce proceedings, suggested coordinated planning rather than responsive decision-making about changed circumstances. This discovery transforms our entire legal strategy, Jennifer explained during a comprehensive case review following the evidence analysis. Instead of defending your travel schedule against claims of instability, we can now demonstrate that you provide the consistency and continuity that Michael's undisclosed plans would disrupt. The evidence also provided foundation for challenging the credibility of other claims Michael's legal team had presented. If they had misrepresented his work responsibilities and failed to disclose relocation plans, their arguments about his superior availability and commitment to local stability became questionable across all aspects of their case presentation. Dr. Sarah Rodriguez, the child psychologist conducting custody evaluations, incorporated the new evidence into her assessment of both parents' long-term planning and commitment to the children's best interests. Her updated evaluation report noted significant concerns about the lack of transparency regarding Michael's career plans and the potential impact of undisclosed relocation on Emma's and Daniel's educational and social development. The failure to disclose major life changes that would affect the children's living situation raises questions about decision-making transparency and commitment to collaborative co-parenting, Dr. Rodriguez noted in her supplemental evaluation report. Effective co-parenting requires honest communication about circumstances that affect children's welfare and development. Margaret's guidance proved crucial in understanding how to present this evidence effectively without appearing vindictive or opportunistic. Her experience with family court proceedings provided strategic framework for demonstrating that the discovery of undisclosed information was relevant to assessing each parent's commitment to transparency and long-term planning for the children's benefit. The court needs to understand that this is not about attacking Michael's character or career choices, Margaret explained as we developed presentation strategy for the new evidence. This is about ensuring that custody decisions are based on accurate and complete information about each parent's actual circumstances and intentions. The revelation of Michael's undisclosed plans also highlighted the effectiveness of my systematic approach to communication and planning regarding decisions that affected Emma and Daniel. Throughout the divorce proceedings, I had provided comprehensive disclosure of my travel schedules, career development plans, and long-term goals for maintaining our family's stability despite changed circumstances. My commitment to transparency had extended to sharing detailed information about potential international opportunities that might arise in future years, including discussion of how such opportunities could be managed to maintain the children's educational continuity and social relationships. This proactive communication contrasted sharply with Michael's failure to disclose significant changes that were already finalized and would directly impact our children's living situation. The strategic implications of this discovery extended beyond the immediate custody proceedings to establish principles about honesty and transparency that would govern our co-parenting relationship throughout Emma's and Daniel's development. The evidence demonstrated that effective collaborative parenting required complete disclosure of circumstances and plans that affected children's welfare, regardless of whether such disclosure might complicate legal proceedings. Margaret's analysis also revealed that Michael's undisclosed relocation plans contradicted his fundamental arguments about the importance of stability and consistent local presence for children's development. If geographic stability was truly his primary concern, accepting a position that required moving Emma and Daniel to a different state undermined the logical foundation of his custody petition. The discovery of this information provides opportunity to demonstrate that your international career actually offers superior stability compared to the undisclosed changes that Michael has planned, Margaret explained as we finalized our strategic response to the evidence. Your travel occurs within the context of maintained residence, school enrollment, and community relationships. His plans involve disrupting all of these stability factors while criticizing you for lesser disruptions. The truth revealed through Margaret's investigation had transformed our legal position from defensive response to Michael's stability arguments to proactive demonstration of superior planning and transparency. The evidence provided foundation for arguing that my approach to balancing career and family responsibilities was not only effective, but demonstrated greater commitment to the children's long-term welfare than the alternative arrangement Michael had proposed. This discovery marked a crucial turning point in the custody proceedings, shifting the focus from evaluation of my travel schedule to assessment of each parent's commitment to honest communication and collaborative decision-making about circumstances affecting our children's development and future opportunities. The weight of evidence uncovered through Margaret Walsh's investigation presented me with the most consequential decision of my professional and personal life. Armed with documentation of Michael's undisclosed relocation plans and misrepresentation of his work responsibilities, I possessed the foundation for a compelling legal case that could fundamentally alter the trajectory of our custody proceedings. However, utilizing this evidence would require a strategic approach that balanced aggressive advocacy for my children's welfare with maintaining the integrity and transparency that I believed were essential for effective co-parenting relationships. The discovery of Michael's deception had created multiple strategic pathways, each carrying distinct risks and potential outcomes that would affect Emma and Daniel's future development and family stability. Margaret's experience with similar cases provided valuable guidance about the legal implications of different approaches, while Jennifer Morrison's expertise in family law offered practical insights about how family court judges typically responded to evidence of misrepresentation in custody proceedings. Margaret recommended a comprehensive approach that would present the evidence of Michael's undisclosed plans within the broader context of evaluating each parent's commitment to transparency and collaborative decision-making. This strategy would demonstrate that the issue extended beyond specific instances of misrepresentation to fundamental differences in our approaches to communication and planning, regarding decisions that affected our children's welfare. Victoria, the evidence we have uncovered provides foundation for several different legal strategies, Margaret explained during a critical strategy session conducted via secure video conference while I was completing a client engagement in San Francisco. We can pursue aggressive confrontation about the misrepresentation, focus on the substantive implications of his undisclosed relocation plans, or present a more comprehensive case about the superior stability and transparency your approach provides. The decision required careful consideration of both immediate legal advantages and long-term implications for our family dynamics. Pursuing an aggressive strategy that emphasized Michael's deception might generate favorable court rulings, but could escalate conflict in ways that would ultimately harm Emma and Daniel's adjustment to our changed family circumstances. Alternatively, focusing primarily on the substantive implications of his relocation plans would address the court's concerns about stability, while maintaining a more collaborative tone that could facilitate better co-parenting relationships in the future. This approach would demonstrate my commitment to prioritizing our children's welfare over opportunities for legal advantage. The third option involved presenting a comprehensive case that positioned my international career and systematic approach to communication as superior alternatives to the instability and lack of transparency that Michael's undisclosed plans represented. This strategy would transform the custody proceedings from defensive response to his criticisms into proactive demonstration of the advantages my approach provided for Emma and Daniel's development. Jennifer Morrison provided practical guidance about how family court judges typically responded to evidence of misrepresentation in custody cases. Her experience suggested that judges appreciated parents who addressed deception professionally rather than vindictively, focusing on implications for children's welfare rather than opportunities for personal advantage. The court will be more responsive if we present this evidence as information relevant to assessing each parent's decision-making capabilities, rather than as ammunition for attacking Michael's character, Jennifer advised during our legal strategy development session. Judges want to see that you are focused on what serves the children's best interests rather than what provides tactical advantage in legal proceedings. This guidance aligned with my professional instincts about strategic communication and relationship management. Throughout my international business career, I had learned that sustainable success required maintaining professional relationships, even when addressing significant disagreements or conflicts. The same principles applied to custody proceedings, where long-term co-parenting effectiveness would depend on establishing patterns of respectful communication, despite legal adversity. The decision-making process also required evaluation of how different strategic approaches would affect Emma and Daniel's emotional adjustment to our divorce and custody arrangements. Dr. Sarah Rodriguez, the child psychologist conducting our family evaluation, had emphasized that children's long-term welfare depended not only on custody schedules and residential arrangements, but on their parents' ability to maintain respectful communication and collaborative decision-making. Emma and Daniel are closely observing how you and Michael handle disagreements and conflicts, Dr. Rodriguez had explained during her assessment process. The strategies you use during custody proceedings will influence their understanding of appropriate conflict resolution and communication patterns that they will carry into their own relationships throughout their lives. Quote, "This perspective reinforced my commitment to pursuing legal strategies that demonstrated the values and communication skills I wanted to model for my children. Rather than viewing the custody battle as an opportunity to defeat Michael, I needed to approach it as a chance to demonstrate effective advocacy, strategic thinking, and principled decision-making under pressure. The choice ultimately crystallized around the fundamental question of what kind of resolution would best serve Emma and Daniel's long-term development and family stability. Michael's undisclosed relocation plans represented a direct threat to their educational continuity and social relationships, but my response to this threat would establish precedents for how we addressed future disagreements and challenges as co-parents. Margaret's recommendation was to pursue the comprehensive strategy that would present my international career as providing superior stability and transparency compared to Michael's undisclosed changes. This approach would address the court's concerns about travel-related disruption, while demonstrating that my systematic approach to communication and planning offered greater consistency than the alternative arrangement Michael had proposed. The evidence supports a proactive case that positions your career and communication practices as advantages rather than liabilities, Margaret explained as we finalized our strategic approach. We can demonstrate that your international experience has enhanced your planning capabilities and commitment to transparency in ways that directly benefit Emma and Daniel's development. This strategy required comprehensive preparation that would present evidence about Michael's undisclosed plans within the broader context of evaluating each parent's long-term commitment to collaborative decision-making and children's welfare. The approach would avoid personal attacks or vindictive characterizations, while clearly demonstrating the implications of his deception for our children's stability and development. The preparation process involved developing detailed presentation materials that would walk the court through the timeline of Michael's career changes and relocation planning, contrasting his lack of disclosure with my proactive communication about potential career developments and their implications for family planning. This comparison would highlight fundamental differences in our approaches to transparency and collaborative decision-making. Jennifer worked with Margaret to structure legal arguments that would emphasize the substantive implications of Michael's undisclosed plans rather than focusing primarily on the deception itself. This approach would demonstrate that our concerns extended beyond procedural fairness to genuine worry about how his decision-making patterns would affect Emma and Daniel's future welfare and development. The decision also required consideration of how to address Michael's likely response to presentation of evidence about his undisclosed relocation plans. His legal team would probably argue that his career advancement opportunities should be supported rather than penalized, and that his failure to disclose the timing of these changes was an oversight rather than intentional misrepresentation. Margaret's experience with similar cases provided valuable guidance about anticipating and responding to these defensive arguments. Her recommendation was to focus on the impact of undisclosed changes on children's stability rather than debating Michael's motivations for withholding information. The court's primary concern will be how these undisclosed plans affect Emma and Daniel's welfare rather than whether Michael intended to deceive anyone, Margaret explained as we developed response strategies for anticipated counterarguments. We need to demonstrate that your approach to communication and planning provides superior stability regardless of his intentions. This perspective reinforced the importance of maintaining focus on our children's best interests throughout the legal proceedings. The evidence about Michael's undisclosed plans was valuable not because it provided opportunities for personal advantage, but because it revealed information relevant to assessing each parent's commitment to collaborative decision-making and transparency. The final component of the decision involved determining how to present this evidence in ways that would maintain possibilities for effective co-parenting relationships after the custody proceedings concluded. Margaret emphasized that custody battles often established communication patterns that persisted throughout children's development, making it crucial to demonstrate the values and approaches that would support long-term family success. Your response to this situation will influence not only the immediate custody outcome, but also the foundation for co-parenting relationships throughout Emma and Daniel's childhood and adolescence, Margaret observed as we considered different presentation approaches. The strategy you choose should reflect the kind of collaborative relationship you want to maintain with Michael in the future. This long-term perspective guided my ultimate decision to pursue the comprehensive strategy that would present my international career and communication practices as providing superior stability and transparency for our children's development. The approach would address Michael's undisclosed plans professionally and systematically, while avoiding personal attacks or vindictive characterizations that could escalate conflict unnecessarily. The decision represented a commitment to demonstrating the values and communication skills that I believed were essential for effective parenting and professional relationships. Rather than viewing the custody proceedings as a battle to be won, I chose to approach them as an opportunity to model strategic thinking, principled advocacy, and respectful communication under challenging circumstances. This strategic choice would guide our preparation for the upcoming custody hearings and establish the foundation for presenting a compelling case about the advantages my international career provided for Emma and Daniel's development. The decision also reflected my commitment to maintaining focus on our children's long-term welfare rather than pursuing opportunities for short-term legal advantage. The comprehensive approach would require extensive preparation and sophisticated presentation of complex evidence, but it offered the potential for outcomes that would serve Emma and Daniel's best interests while establishing positive precedents for future co-parenting collaboration. The strategy aligned with my professional values and personal commitment to demonstrating excellence and integrity in all aspects of my life. Margaret's guidance had provided the framework for transforming a defensive response to Michael's custody petition into a proactive demonstration of superior planning and communication capabilities. The evidence about his undisclosed relocation plans would serve as foundation for a broader case about the advantages of transparency, systematic planning, and international perspective for children's development in an increasingly connected global economy. The decision marked a crucial transition from evidence gathering and strategic planning to active implementation of our legal strategy. The comprehensive approach would test every aspect of my professional communication skills, while requiring sustained commitment to the values and principles that I wanted to model for Emma and Daniel throughout their development. The transition from strategic planning to active legal proceedings required implementation of the comprehensive case presentation strategy that Margaret Walsh and Jennifer Morrison had developed through months of meticulous preparation. The initial phase of courtroom advocacy would test my ability to maintain professional composure while presenting complex evidence about the advantages my international career provided for Emma and Daniel's development, contrasted against the instability and lack of transparency represented by Michael's undisclosed relocation plans. The preliminary custody hearing, scheduled for a Tuesday morning in King County Family Court, represented the first opportunity to present our carefully constructed narrative before Judge Patricia Williamson, a family court veteran with 23 years of experience in custody proceedings involving professional parents. Judge Williamson's reputation suggested she appreciated thorough preparation and evidence-based arguments, but remained skeptical of parents who appeared to prioritize career advancement over collaborative co-parenting relationships. Jennifer Morrison had prepared extensively for this initial presentation, understanding that first impressions in family court proceedings often established judicial perspectives that influenced subsequent rulings throughout lengthy custody cases. Her preparation included detailed analysis of Judge Williamson's previous decisions in cases involving parental travel requirements, her documented preferences for evidence presentation formats, and her typical responses to arguments about international career benefits versus local stability concerns. Victoria, this preliminary hearing will establish the foundation for how Judge Williamson evaluates our entire case, Jennifer explained during our final preparation session the evening before court proceedings began. She will be assessing not only the specific evidence we present, but your credibility, communication style, and apparent commitment to collaborative decision-making with Michael despite the legal conflict. The courtroom environment represented a dramatic departure from the international business settings where I typically conducted professional presentations. The formal legal atmosphere, with its emphasis on procedural compliance and adversarial positioning, required adaptation of communication approaches that had proven successful in corporate negotiation and client relationship management contexts. Margaret Walsh's coaching had prepared me for these adjustments, emphasizing that effective family court advocacy required demonstration of parental commitment and child-focused decision-making, rather than the strategic maneuvering and competitive positioning that characterized business negotiations. The judicial audience expected evidence of genuine concern for children's welfare rather than sophisticated arguments about competitive advantages or market positioning. The preliminary hearing began with presentation of basic case parameters and scheduling for comprehensive evidence review. Judge Williamson's initial questions focused on practical considerations about temporary custody arrangements and communication protocols, rather than the substantive arguments about career benefits and stability concerns that would dominate later proceedings. However, even these preliminary discussions revealed significant advantages from our comprehensive preparation approach. When Judge Williamson inquired about proposed temporary visitation schedules, I was able to present detailed documentation of communication systems and coordination protocols that demonstrated systematic attention to Emma and Daniel's needs during my business travel periods. Michael's attorney, by contrast, appeared unprepared for questions about how his undisclosed relocation plans would affect temporary arrangements and transition planning for the children. His responses suggested that he had not developed comprehensive strategies for maintaining continuity of care and communication during his anticipated move to Portland. Mr. Chen, can you clarify your current employment obligations and any anticipated changes that might affect your availability for custody responsibilities? Judge Williamson asked during the preliminary questioning period, providing an opportunity for disclosure of the relocation plans that had been concealed throughout previous proceedings. Michael's response revealed the strategic disadvantage created by his lack of transparency about career changes and relocation planning. His acknowledgement that he had accepted a position requiring relocation to Portland generated immediate judicial concern about the stability and continuity arguments that had formed the foundation of his custody petition. "When were you planning to inform the court about this relocation?" Judge Williamson inquired, her tone indicating surprise and potential concern about the timing of this disclosure relative to custody proceedings that had emphasized his local presence and stability as primary advantages. The exchange highlighted the contrast between our proactive communication approach and Michael's reactive disclosure pattern. Throughout the divorce proceedings, I had provided comprehensive information about potential career developments and their implications for family planning, while Michael had withheld significant information about changes that would directly affect our children's living situation and educational continuity. Jennifer Morrison capitalized on this opportunity by requesting permission to present evidence about the comparative transparency and planning approaches each parent had demonstrated throughout the custody proceedings. Her presentation included documentation of my systematic communication about travel schedules, career development opportunities, and long-term planning for maintaining family stability despite international work requirements. Your Honor, the contrast in communication approaches reflects fundamental differences in how each parent approaches collaborative decision-making and transparency about circumstances affecting the children's welfare, Jennifer argued during her preliminary statement. Ms. Chen has consistently provided comprehensive disclosure about her career requirements and has developed systematic protocols for maintaining involvement in the children's daily lives and educational development. The preliminary hearing also provided opportunity to introduce expert witness testimony from Dr. Elena Vasquez about the developmental benefits of international exposure and cultural diversity for children's cognitive and emotional growth. Dr. Vasquez's credentials and research background established foundation for later testimony about how my career enhanced rather than hindered my effectiveness as a parent. Dr. Vasquez has conducted extensive research on the impact of global exposure on children's development, Jennifer explained during her witness introduction. Her findings demonstrate that carefully managed international experiences contribute to enhanced problem-solving abilities, cultural competency, and adaptability that serve children throughout their academic and professional development. Judge Williamson's initial response to this expert witness introduction suggested cautious interest rather than immediate acceptance. Her questions focused on the methodology and scope of Dr. Vasquez's research, indicating that she would require substantial evidence before accepting arguments about the benefits of parental travel for children's development. The preliminary proceedings also revealed Michael's legal strategy for responding to evidence about his undisclosed relocation plans. His attorney argued that career advancement opportunities should be supported rather than penalized, and that the timing of his disclosure reflected practical considerations about finalizing employment arrangements rather than intentional concealment. Mr. Chen's career advancement represents positive development for his ability to provide financial stability and educational opportunities for the children, Michael's attorney argued during his preliminary statement. The relocation to Portland would provide access to superior educational resources and cultural opportunities within a thriving metropolitan environment. This argument represented a strategic pivot from previous emphasis on local stability and consistent presence to focus on career advancement and educational opportunities. The shift suggested recognition that the disclosed relocation plans had undermined his original stability-based arguments and required development of alternative justifications for custody arrangements. Margaret Walsh had anticipated this strategic adjustment and had prepared comprehensive responses that would contrast Michael's reactive career planning with my systematic approach to balancing professional advancement with family stability. Our preparation included evidence about the superior educational resources and international opportunities available through my Seattle-based career, compared to the alternatives that relocation to Portland would provide. The preliminary hearing concluded with Judge Williamson's establishment of comprehensive evidence review schedules and procedural requirements for expert witness testimony. Her approach suggested thorough and systematic evaluation rather than quick resolution based on initial impressions or simplified arguments about travel versus stability. This case involves complex questions about the relationship between parental career requirements and children's developmental needs, Judge Williamson observed during her concluding remarks. The court will require comprehensive evidence about the practical implications of different custody arrangements and the long-term impact on the children's educational and social development. The scheduling established by Judge Williamson provided adequate time for presentation of the comprehensive case materials that Margaret and Jennifer had developed through months of systematic preparation. The timeline would allow for detailed expert witness testimony, thorough review of educational and developmental evidence, and comprehensive analysis of each parent's long-term planning and communication approaches. Following the preliminary hearing, the response from Emma and Daniel to the court proceedings provided additional validation of our strategic approach. Both children demonstrated remarkable maturity in discussing the custody evaluation process and expressed clear preferences for maintaining their current educational and social relationships in Seattle rather than relocating to Portland. Emma's perspective proved particularly sophisticated in addressing the court-appointed child advocate who conducted separate interviews with both children. "I want to stay in Seattle because my school has programs that prepare students for international business careers," Emma explained according to the advocate's report. "Mom's work has helped me understand what I want to study in college, and I think staying here gives me better preparation for the future I want." Daniel's comments reflected his younger age but demonstrated similar understanding of the advantages provided by our current living arrangement. "I like learning about different countries when Mom travels for work," Daniel told the child advocate. "She helps me with my geography projects and teaches me about how business works in different places. I want to keep living with Mom because she explains interesting things about the world." These perspectives from the children themselves provided powerful validation of our arguments about the educational and developmental benefits of my international career. Their comments demonstrated that they viewed my work as contributing to their learning and future preparation, rather than creating instability or neglect in their daily lives. The child advocate's preliminary report also noted the children's sophisticated understanding of cultural differences and international perspectives compared to their peers. Both Emma and Daniel demonstrated advanced knowledge about global economics, international relations, and cross-cultural communication that exceeded typical expectations for their age groups. Both children exhibit remarkable maturity and global awareness that appears directly related to their mother's international business experience, the child advocate noted in her preliminary assessment. They demonstrate strong emotional bonds with both parents, but express clear preferences for maintaining their current educational and social environment in Seattle. The preliminary hearing phase had established foundation for presenting our comprehensive case about the advantages of my approach to balancing international career responsibilities with effective parenting. The contrast between our proactive communication and systematic planning versus Michael's reactive disclosure and last-minute relocation arrangements had created strategic advantages that aligned with our evidence about superior stability and transparency. The early implementation phase had also revealed the effectiveness of Margaret Walsh's preparation strategy and Jennifer Morrison's courtroom advocacy approach. Their collaboration had transformed potentially defensive responses to Michael's stability arguments into proactive demonstration of superior planning and communication capabilities that served Emma and Daniel's long-term developmental needs. The foundation established through these preliminary proceedings would support the comprehensive evidence presentation and expert witness testimony that would dominate the subsequent phases of custody evaluation. The early results suggested that our systematic preparation and transparent communication approach was resonating with Judge Williamson's emphasis on evidence-based decision-making and long-term planning for children's welfare. The transition from strategic planning to active courtroom advocacy had confirmed the viability of our comprehensive approach while establishing momentum for the detailed evidence presentation that would ultimately determine the custody outcome. The preliminary phase had demonstrated that thorough preparation and principled advocacy could effectively counter arguments based on traditional assumptions about the relationship between career travel and effective parenting. The comprehensive evidence presentation phase required transformation of months of systematic documentation into persuasive courtroom testimony that would establish the foundation for Judge Williamson's custody determination. This phase would test the effectiveness of Margaret Walsh's strategic framework and demonstrate whether our systematic approach to highlighting the advantages of my international career could overcome traditional judicial preferences for geographic stability and consistent local presence. The evidence presentation began with establishment of my professional qualifications and the nature of my international business responsibilities. Jennifer Morrison structured this testimony to demonstrate that my career represented expertise and leadership in global market development rather than routine business travel that could be managed through alternative arrangements or reduced frequency. The distinction was crucial for establishing that my international work contributed specialized value that enhanced my family's financial security and our children's future educational opportunities. My testimony regarding professional responsibilities required careful balance between demonstrating expertise and avoiding the impression that career achievements took precedence over family commitments. Jennifer's preparation had emphasized the importance of consistently connecting professional accomplishments to benefits for Emma and Daniel, rather than presenting career success as independent validation of personal worth or achievement. Ms. Chen, can you explain how your role as Senior Director of International Partnership Development contributes to your family's stability and your children's educational opportunities? Jennifer asked during the opening phase of evidence presentation, providing opportunity to establish the connection between professional responsibilities and parenting effectiveness. My international work provides financial resources that enable Emma and Daniel to attend private schools with advanced programs in global studies and foreign language instruction, I explained, referencing specific educational advantages that would not be available through alternative career arrangements. The relationships I have developed through international business have also created mentorship opportunities and educational exchanges that expose them to career possibilities and cultural perspectives they would not encounter through traditional local experiences. The testimony included specific examples of how my professional network had enhanced the children's educational development. Emma's correspondence with the Colombian student had evolved into a formal international pen pal program at her school, connecting American students with peers in Latin American countries to practice Spanish language skills and learn about different educational systems and cultural traditions. Daniel's interest in geography and international economics had been nurtured through access to executives and researchers in my professional network, who had provided guest presentations at his school about global trade relationships and economic development strategies. These presentations had inspired several students to develop research projects about international business topics for their science fair presentations. The evidence presentation also documented the systematic protocols I had developed for maintaining consistent involvement in the children's daily lives and educational progress, despite irregular travel schedules. These protocols demonstrated organizational capabilities and commitment to family priorities that contradicted arguments about travel-related instability or neglect of parenting responsibilities. The communication systems included scheduled video conferences that occurred at consistent times relative to the children's routines, rather than my travel schedule, ensuring they could anticipate regular contact regardless of my geographic location. These conversations followed structured formats that included homework review, discussion of daily activities, planning for upcoming events, and opportunities for them to share their thoughts and concerns about school or social situations. Jennifer's presentation of this evidence emphasized the intentionality and sophistication of these communication approaches compared to typical parenting practices. These protocols demonstrate that Ms. Chen has developed more systematic and reliable communication with her children than many parents who are physically present but may not maintain consistent engagement with their daily activities and educational development, Jennifer argued during her evidence summary. The documentation included examples of how these communication systems had enabled me to provide immediate support during challenging situations that occurred while I was traveling for business. When Emma had experienced difficulty with a group project at school, our scheduled video conferences had allowed me to help her develop problem-solving strategies and coordinate with teachers to address the interpersonal conflicts that were affecting her academic performance. Similarly, when Daniel had struggled with a mathematics concept that was creating frustration and anxiety about his homework assignments, our regular communication schedule had enabled me to provide additional tutoring and to arrange for supplemental resources that helped him master the material and regain confidence in his mathematical abilities. The evidence presentation phase also included testimony from educational professionals who had observed the children's development and could provide expert assessment of how my international career had influenced their academic progress and social skills. Emma's Spanish language instructor testified about her advanced proficiency and cultural awareness compared to students who had learned exclusively through classroom instruction. Emma demonstrates sophisticated understanding of Spanish grammar and vocabulary that reflects exposure to native speakers and authentic cultural contexts, the language instructor explained during her testimony. Her ability to discuss complex topics and navigate cultural nuances suggests immersion experiences that extend beyond traditional classroom learning opportunities. Daniel's social studies teacher provided similar testimony about his exceptional knowledge of global economics and international relations. Daniel consistently contributes insights to classroom discussions that reflect understanding of how international trade and cultural exchange affect local communities and national economies, the teacher noted. His questions and observations suggest exposure to real-world applications of the concepts we study in our curriculum. Quote, "This educational testimony established that the children's exposure to my international work had generated measurable academic advantages, rather than creating disruption or instability in their learning processes. The evidence demonstrated that their global awareness and cultural competency exceeded typical expectations for their age groups, and provided foundation for enhanced educational opportunities throughout their development." The testimony phase also addressed concerns about the children's social adjustment and peer relationships despite my travel schedule. Emma's school counselor testified that she demonstrated strong leadership skills and served as a mentor for students from diverse cultural backgrounds who were adjusting to American educational systems. Emma's international awareness and cultural sensitivity have made her particularly effective in helping immigrant students navigate social situations and academic expectations, the school counselor explained. She demonstrates remarkable empathy and communication skills that reflect exposure to diverse perspectives and cultural practices. Daniel's athletic coach provided testimony about his teamwork capabilities and adaptability to changing circumstances. Daniel consistently demonstrates positive attitude and resilience when facing unexpected challenges or changes in team strategies, the coach noted. He seems comfortable with uncertainty and approaches new situations with curiosity rather than anxiety. This testimony supported arguments that my travel schedule had enhanced rather than hindered the children's development of important life skills such as adaptability, cultural awareness, and effective communication with people from diverse backgrounds. The evidence suggested that exposure to international perspectives through my career had prepared them to navigate an increasingly interconnected global economy with confidence and competence. The foundation-building phase also included presentation of comparative evidence about the stability and transparency advantages of my approach versus the alternatives represented by Michael's undisclosed relocation plans. Jennifer structured this comparison to highlight fundamental differences in our approaches to communication and long-term planning for the children's welfare. The evidence demonstrated that my international travel occurred within the context of maintained residence, consistent school enrollment, and stable community relationships, while Michael's relocation plans would disrupt all of these stability factors for Emma and Daniel. The comparison emphasized that travel-related temporary absences were less disruptive than permanent geographic relocation that would require adjustment to new schools, social relationships, and community environments. The evidence establishes that Ms. Chen's international work enhances family stability through increased financial resources and educational opportunities while maintaining consistent residential and educational arrangements, Jennifer argued during her comparative analysis. Mr. Chen's relocation plans, by contrast, would require the children to abandon established relationships and educational programs for uncertain alternatives in an unfamiliar environment. The presentation included detailed analysis of the educational resources and extracurricular opportunities available through Emma's and Daniel's current schools, compared to alternatives that would be accessible following relocation to Portland. This comparison demonstrated that maintaining their Seattle-based educational arrangements would provide superior preparation for college admission and career development. Emma's current school offered advanced placement courses in international relations and global economics that aligned with her expressed interest in pursuing international business careers. The school also maintained formal exchange programs with institutions in Europe and Asia that would provide opportunities for supervised international study during her high school years. Daniel's elementary school had specialized programs in multilingual education and cultural studies that supported his developing interests in geography and international affairs. The school's curriculum included systematic exposure to diverse cultural traditions and global economic relationships that provided foundation for advanced study in these areas during his secondary education. The evidence presentation established that my systematic approach to balancing international career responsibilities with family commitments had generated measurable advantages for Emma and Daniel's educational development and social adjustment. The foundation phase demonstrated that my travel schedule occurred within the context of enhanced stability rather than creating disruption to their daily lives or long-term development opportunities. The comprehensive nature of this evidence presentation reflected Margaret Walsh's strategic emphasis on proactive demonstration of advantages rather than defensive response to stability concerns. The testimony and documentation had transformed the custody proceedings from evaluation of travel-related risks to assessment of which parental approach would provide superior preparation for the children's future success and development. The foundation established through this evidence presentation phase would support the expert witness testimony and comparative analysis that would dominate subsequent proceedings. The systematic documentation had created compelling narrative about the benefits of international exposure and cultural diversity for children's cognitive and emotional development, while demonstrating practical protocols for maintaining family stability and communication effectiveness, despite demanding professional responsibilities. The momentum generated through comprehensive evidence presentation encountered significant resistance during the cross-examination phase, when Michael's legal team launched aggressive challenges designed to undermine the credibility of my international career benefits and expose potential vulnerabilities in my parenting approach. This phase would test not only the strength of our documented evidence but my ability to maintain professional composure while addressing pointed questions about my priorities, decision-making processes, and long-term commitment to collaborative co-parenting relationships. Michael's attorney, David Richardson, was a seasoned family law practitioner with extensive experience in custody cases involving high-achieving professional parents. His reputation suggested sophisticated understanding of how to exploit perceived contradictions between career ambition and family commitment, particularly in cases where mothers pursued demanding international responsibilities that required extended periods away from their children. Richardson's cross-examination strategy became apparent during his opening questions, which focused on specific instances when my business travel had coincided with important family events or required last-minute schedule adjustments that affected Emma and Daniel's planned activities. His approach was designed to create doubt about whether my systematic communication protocols could adequately substitute for physical presence during crucial moments in my children's development. Ms. Chen, during your testimony you emphasized your commitment to maintaining involvement in your children's educational activities. Richardson began during his cross-examination presentation. Can you explain why you were unable to attend Emma's science fair presentation last spring, when she had specifically requested your presence for this important academic milestone? The question represented exactly the type of challenge that Margaret Walsh had prepared me to address through comprehensive documentation and strategic response frameworks. The specific incident Richardson referenced had occurred during a critical client presentation in Singapore that could not be rescheduled without jeopardizing a multi-million-dollar partnership agreement that would affect dozens of employees and their families. Mr. Richardson, I was unable to attend Emma's science fair in person due to contractual obligations that involved presenting our company's sustainability initiatives to potential partners in Southeast Asia, I replied, maintaining the calm and measured tone that Jennifer Morrison had emphasized during our preparation sessions. However, I arranged for my sister to attend as my representative. I participated in Emma's final practice session via video conference the evening before her presentation, and I was available by phone throughout the event to provide encouragement and support. Richardson's follow-up questions attempted to characterize this remote participation as inadequate substitution for maternal presence during an important academic achievement. His line of questioning suggested that virtual communication, regardless of its sophistication and consistency, could not provide the emotional support and validation that children required during significant milestones and challenging situations. Ms. Chen, Do you believe that video conference participation provides the same level of emotional support for your daughter as physical presence would have provided during her science fair presentation? Richardson asked, attempting to force acknowledgement that my career priorities had required compromising my children's emotional needs. Margaret Walsh's preparation had anticipated this type of questioning and had developed response strategies that would reframe the conversation from defensive justification to proactive demonstration of enhanced support systems. Her coaching emphasized the importance of acknowledging the reality of schedule conflicts while demonstrating that my approach provided superior preparation and follow-up support compared to typical parental involvement patterns. Mr. Richardson, my participation in Emma's science fair preparation extended over several weeks and included research assistance, presentation coaching, and coordination with her teacher about optimal display arrangements. I responded, drawing upon the comprehensive documentation we had prepared about my involvement in the children's academic projects. While I would have preferred to attend in person, the support system I had established ensured that Emma received more comprehensive preparation and encouragement than she would have received through attendance at the final presentation alone. The cross-examination continued with questions about my long-term career plans and whether my international responsibilities would increase in ways that could further limit my availability for parenting duties. Richardson's questions were designed to create uncertainty about my commitment to maintaining family priorities if additional career advancement opportunities arose that would require even more extensive travel obligations. These questions represented a strategic challenge because they required me to balance demonstration of professional competence and growth potential with reassurance about my sustained commitment to Emma and Daniel's welfare. Richardson was attempting to characterize career ambition as inherently incompatible with effective mothering, particularly in cases where professional advancement might involve increased international responsibilities. Ms. Chen, if you were offered a promotion to Regional Director for Asia-Pacific Operations, a position that would require quarterly extended assignments in multiple countries, would you accept this opportunity despite the increased impact on your children's daily routines? Richardson asked, posing a hypothetical scenario that would force me to choose between professional advancement and family stability. Margaret's preparation had included extensive discussion of how to address hypothetical scenarios that attempted to force false choices between career development and parenting effectiveness. Her guidance emphasized the importance of demonstrating that my decision-making processes always prioritized Emma and Daniel's welfare, while acknowledging that their long-term interests might sometimes require short-term schedule adjustments. Mr. Richardson, any significant career decision would be evaluated based on its implications for my children's long-term educational opportunities and financial security, I replied, utilizing the framework Margaret had provided for addressing hypothetical advancement scenarios. I would not accept additional responsibilities that would compromise my ability to maintain consistent involvement in Emma and Daniel's development, but I would carefully consider opportunities that could enhance their future educational and career possibilities. The cross-examination also included challenges to the expert witness testimony about the developmental benefits of international exposure and cultural diversity. Richardson attempted to characterize Dr. Elena Vasquez's research as theoretical academic analysis that did not necessarily apply to the specific circumstances of my children's situation or account for the potential negative effects of parental absence during critical developmental periods. Dr. Vasquez, your research focuses on children who participate in structured international educational programs with comprehensive supervision and support systems, Richardson argued during his cross-examination of our expert witness. Can you demonstrate that these findings apply to children whose international exposure occurs primarily through their mother's business travel, rather than through formal educational exchanges? Dr. Vasquez's response demonstrated the thoroughness of her evaluation process and the specific applicability of her findings to Emma and Daniel's situation. Her testimony provided detailed analysis of how my systematic approach to involving the children in my international work had created structured learning opportunities that aligned with the conditions her research had identified as most beneficial for cognitive and emotional development. Mr. Richardson, my evaluation of Emma and Daniel included comprehensive assessment of their specific international experiences and the learning opportunities these experiences had provided, Dr. Vasquez explained during her response to cross-examination. Their exposure to diverse cultures and global perspectives through their mother's career has occurred within structured frameworks that include preparation, supervised participation, and systematic follow-up discussion. These conditions align precisely with the optimal learning environments my research has identified. The external pressure phase also included challenges from the court-appointed child advocate, who raised questions about whether Emma and Daniel's expressed preferences for maintaining their current living arrangements reflected genuine understanding of the alternatives or simply loyalty to the parent with whom they had spent more time during the separation period. Up next, you've got two more standout stories right on your screen. If this one hit the mark, you won't want to pass these up. Just click and check them out. And don't forget to subscribe and turn on the notification bell so you don't miss any upload from us.